This is another edition of the Scale of Justice. This week, our attention is drawn to the arbitration community with the passage of Arbitration and Mediation Act 2023. Nigeria is expected to be the arbitration hub on the African continent. Also on the program is the coming together of members of the bench to cross-fertilize ideas on the interpretation of money laundering, counter-terrorism, and trans-border crimes legislations to save the country from financial and terrorism crimes. These and more will be featuring on the Scale of Justice this week. Welcome on the Scale of Justice. Dele Atumbi is my name. The Asian community in the last 18 years have been striving to make Nigeria the hub of arbitration and mediation on the continent. Concerted efforts were put into this to ensure that the legislation is in tandem with what is obtainable globally. These deliberate efforts, starting from late Justice Olakunle Orojo to Fumi Roberts, have paid off with the passage and assent to the Arbitration and Mediation Act 2023. The scale sought the view of one of the members of the committee who pushed so hard for the passage of the Arbitration and Mediation Act. He is a legal practitioner, a professor of commercial law, and a chartered arbitrator, Paul Idornigie SAN. Going down the memory lane, how would you describe customary arbitration in Nigeria?
Before the advent of colonial rule with the English type courts, we had our own way of resolving disputes. We had them and we still have them. Disputes were resolved by chiefs, by elders in a place like Benin, the Oba of Benin, the Diowere is the village head, Okaegbe is the ward head. In the eastern part of the country, the Amala. In the western part of the country, the Obas, and in the north, the Emirs. They were resolving disputes using what can refer to as customary arbitration. It is the parties that refer such disputes to them, and the disputes are resolved applying the custom of the area. Over the years, the courts have made various pronouncements on this. As far back as 1952, the Privy Council, when we had West Africa Court of Appeal, when we had the old Supreme Court, up till July last year, the Court of Appeal in Benin made a pronouncement on customary arbitration. But the challenge has always been, when is customary arbitration binding, such that the award can act as res judicata? In other words, that the matter is settled and therefore it cannot be reopened. So over the years, the courts have laid down 5 conditions that for us to have customary arbitration, there must be 1, voluntary submission of the dispute to arbitration. 2, the parties must agree that the outcome of the arbitration is binding on them. 3, the disputes must be resolved in accordance with the custom of the people, or if it's a trade or a profession, the practices of this body. Then 4, the award must be published. And lastly, the parties must accept the outcome of the award at the time it is given. And that when these 5 conditions are met, customary arbitration can act as res judicata. The last judgment, there are many judgments, I will just cite the last one that was decided in July 2022, is called Iyawe and Yero. It's a Court of Appeal decision, the Benin Division of the Court of Appeal. And so, but as I said, there are many cases on the bindingness of customary arbitration.
I will take you now to the issue of the origin of statutory arbitration in Nigeria can be traced to 1889 English Arbitration Act. How relevant were the provisions of this very act to the contemporary arbitration?
In 1914, when the Northern Protectorate and Southern Protectorate were amalgamated, the English Arbitration Act of 1889 became our arbitration ordinance, and it applied throughout the country. Now, when regions were created, it became the Arbitration Act of the Federal Capital Territory of Lagos, arbitration law of the Eastern, Western, and Northern Nigeria. When states were created out of them, they have been adopting this law as their arbitration enactment. But the law deals with just domestic arbitration. It does not deal with commercial arbitration. So by 1985, we have a body called United Nations Commission on International Trade Law, UNCITRAL. UNCITRAL adopted a model law of 1985 that deals with international commercial arbitration. So there was a need for Nigeria to adopt this old English law and also combine it with the UNCITRAL model law of 1985. So on March 11, 1988, the federal military government promulgated the Arbitration and Conciliation Decree. It was a decree then. And as a decree, it was applicable throughout Nigeria. You know, under military rule, the decree is even superior to the Constitution. So if you look at section 58 of the Act, it says it shall apply throughout the Federation. So that decree applied throughout the Federation. But one thing the decree did was, one, to have a uniform law. Again, the military operated a unitary system, a uniform law on arbitration. That decree also provided for conciliation and also provided for the adoption of the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Award.
What was the intent of the Arbitration Act Cap 13, Laws of the Federation of Nigeria, 1958, that was applicable to the Federal Capital Territory?
Same 1889 English Arbitration Act became the Arbitration Act of the federal government. Like I said, because of the nature of the federation, then we had 3 regions and the federal government. That act applied to...
In our previous edition, we commenced our voyage into the provisions of the Arbitration and Mediation Act 2023. This act was passed and assented to after 18 years of deliberate effort to enact an arbitration law for Nigeria. Let's conclude our x-ray of the latest development in our arbitration law with a thought of a university don, a professor of commercial law, and a chartered arbitrator, Paul Idornigie SAN. I'd like to take you on this issue of Justice Olakunle Orojo's committee, in which you are a member, and Nigerians would like to know the terms of reference of that committee that was inaugurated in 2005.
We had the Arbitration and Conciliation Decree, which clearly was outdated, and it had some provisions with regard some repetitive. For instance, sections 4 and 5 of that decree deals with stay of proceedings. Now, section 30 of that decree deals with setting aside of an award on grounds of misconduct. Unfortunately, there's no definition of misconduct in the Act, and therefore, once most parties lose or there's an award against them, they go to court to challenge the award on grounds of misconduct because the word is not defined. So there was a need to redraft that law. And so Orojo's committee was set up. Like I said, at that time, reform of the 1988 decree was imperative. So Orojo committee, our main term of reference was to review the arbitration and ADR laws in Nigeria generally and make recommendations.
Between 2007 and 2016, what was the position of the law concerning arbitration in Nigeria?
Like I said, in 2007, the federal version got to the National Assembly as an executive bill. You know the way the National Assembly works. If a bill is introduced and in the life of that assembly, the bill is not passed, it has to be reintroduced. So when Chibayojo left office as the general, like I said, the bill went as an executive bill. The bill was just lying. It was like an orphan in the National Assembly because nobody to introduce it. We active members of the arbitration committee could not introduce it. But we also believe too that the bill was stale because by 2006, Ocitral, that first sponsored, adopted a model law in 1985, amended that model law. Then other arbitral institutions like the London Court of Arbitration, International Chamber of Commerce Court of Arbitration, they all amended their rules. So there was a need for us to update the first version. So in 2017, we redacted the bill and say call it Arbitration and Conciliation Bill. Now, luckily for us, in 2018, that bill was passed by Senate, but the House could not pass it before the end of the seventh assembly, and so we were stuck with the bill. Again, it was still lying in the National Assembly, but there were many things we introduced into that bill, which we call novel provisions. But I think because the last version of 2019 included more novel provisions.
Between 2016 and 2023, the Fumi Roberts Committee played a vital role in the passage of the existing Arbitration Act. As the head of the technical committee then, could you explain further?
Yeah. 2016, the Arbitral Committee in Nigeria, they met and they agreed that there was a need to ensure that the bill was passed into law. So Fumi Roberts was the chairman of what we refer to as Arbitration Reform Committee. I headed the technical committee that did the drafting. I worked with Mr. Isaiah Buzimo, the immediate Attorney General of Delta State. There was also Seinlaya Ojo who worked with us. And we drafted a new bill because by 2018, Ocitral adopted a new modern law on commercial mediation. Prior to that, in 2002, Ocitral had a model law on conciliation. But by 2018, Ocitral felt that the word mediation is more appropriate than conciliation. So Ocitral adopted a new model law on conciliation. That same 2018, the UN adopted a convention on mediation that we refer to as Singapore Convention. So with these two instruments and developments in other jurisdictions, there was a need to redraft the bill. So in 2019, we redacted the bill and changed the name from Arbitration and Conciliation Bill to Arbitration and Mediation Bill. So the Singapore Convention and the Ocitral Model Law on mediation of 2008, informed our change of name from Arbitration and Conciliation Bill to Arbitration and Mediation Bill 2019.
On 20th December 2018, the United Nations General Assembly adopted the Model Law on International Commercial Mediation, amending 2002 International Commercial Conciliation. How did this affect the present act in Nigeria?
The Fumi Robot Committee was also very large. It was a 33-member committee. Let me quickly say this. I may not be able to acknowledge those who played roles in this project because the Roger Committee was made of 15 members. The Arbitration Reform Committee was made of 33 members. If I decide to call all the names, that will occupy the whole time. So that our committee, realizing that we now have a draft bill on mediation, and for us it was a very significant development because there are very few countries that have enactment on mediation. What they generally have is arbitration. So realizing that we are going to have an enactment on mediation, there was a need to adopt the Singapore Convention. Now, we already have, in the case of arbitration, the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Award. So, to enable mediated settlement to be also enforced and recognized, we now decided that in the bill, which will provide for the adoption of the Singapore Convention on the Recognition and Enforcement of Mediated.
On a final note, how will the Arbitration and Mediation Act 2023 impact the arbitration community in Nigeria?
Well, as you will find shortly, when we included the Singapore Convention in the Arbitration and Mediation Bill of 2019, the National Assembly actually passed the bill in 2022 with the Singapore Convention. But for the first time, the bill got to the President. And as is customary, the President referred it to government agencies like the Office of the Honorable Attorney General of the Federation. When it got there, they raised an issue with the bill, that the bill contains Singapore Convention that had not been domesticated. Now, it may tell you to know that when this Singapore Convention was open for signature, Nigeria was one of the first countries to sign it. So, you know, when it comes to international instruments, there's a difference between signature and ratification. So Nigeria signed the convention, but has not yet ratified it. And until Nigeria deposits the instrument of ratification with the UN, it cannot be enforced in Nigeria. The committee had 33 members. And the Arbitration Reform Committee, no, the original committee had 15 members. The Arbitration Reform Committee had 33 members. It is tough for me to start mentioning names because I don't want to mention names and leave out other names. But there are those I must mention. I'll start with the late Orojo. He was our chairman and the main driver of the first draft. Then I'll come to Chief Bayojo SAN, who was the Attorney General that started the process. Then the immediate past Attorney General, Abubakar Malami SAN. The PAMSEC, Assistant General of the Federation, Mrs. Beatrice Jeda Eba. Then the President of NBA, Mr. YC Mikhail SAN. The Chairman, Nigeria branch of the Challenge of Arbitrators, Chief Bola Akiola SAN. Our committee, I must again recognize Mrs. Fumi Roberts, Mr. Isaiah Bozimo, Chilayo Ojo, Professor Wale Olawonyi SAN. For me, I was a part of the original committee. I was also a part of the Arbitration Reform Committee. So for me, I've been involved with this enactment since 2005, and I was involved closely until it was passed into law. In fact, I will not forget 26th of May, 2023. By 10 a.m., I called our contact at the villa. That day was the last working day for the president. By 10 a.m., I called, our bill had not been accepted to. So, and people were waiting until about 12 noon that we got word that our bill has been accepted to, and the whole world, everybody was just jubilating that the journey that started in September 2005 ended on the 26th of May 2023. I am glad for being part of this process.